Ready, start. The petitioner was working as a senior administrative officer in the Justice of ETA at the relevant time when certain complaints were received against him, upon which the administrative judge, finding the complaints to be serious, directed a vigilance inquiry. Full stop. Upon a vigilance inquiry, prima facie, the acts attributed to the petitioner were found to be correct, whereupon a departmental inquiry was initiated. Full stop. After the inquiry, the services of the petitioner have been dispensed with by the impugned order. Full stop. It is firstly urged that the learned district judge, while passing the impugned termination order, has taken into account the allegations of sexual harassment attributed to the petitioner, though it was not a charge for which the inquiry was held, and therefore, it is contended, that the order is vitiated. Full stop. Apparently, 8 charges were framed against the petitioner on various counts, which is evident from the inquiry report and the dismissal order, some of them related to harassment of employees, including by demanding illegal gratification for getting undue favors, etc. Full stop. During the course of inquiry, evidence came on record about sexual harassment of lady employees also, but the order is not based upon it, and the district judge himself has noted that there was no charge of sexual harassment. Full stop. Mere noting of the evidence found during inquiry, without further demonstrating that the order is based upon it, would not vitiate the dismissal order. Full stop. However, the petitioner has failed to demonstrate or convince the court on this aspect. Full stop. None of the two decisions cited are applicable to the present issue, either on facts or on law. Full stop. Thus, the argument merits rejection. Full stop. Lastly, it is urged that the inquiry officer erred in law in rejecting an application for summoning the erstwhile district judge as a witness to support his defense, and as such, sufficient opportunity was not afforded to the petitioner. Full stop. It is also urged that the erstwhile district judge had submitted an affidavit in favor of the petitioner, which was produced but has not been considered by either of the authorities, and thus, also the punishment order is vitiated. Full stop. The inquiry officer has considered the merits of the application for summoning the district judge, and by an exhaustive order dated 6/9/2003 has rejected it, which remains unchallenged. Full stop. However, it is apparent that the inquiry officer, while rejecting the application, apart from other findings, has found that most of the charges were based upon documentary evidence, and the charges with respect to demand of money was to be proved by oral evidence of the employees of the judgeship. Full stop. It has also found that the petitioner had listed and examined as many as 18 defense witnesses, but the name of the district judge, who had since retired, was not mentioned in the list. Full stop. The reasons given by the inquiry officer in rejecting the application appear to be fully justified, and the argument cannot be accepted. Full stop. So far as the affidavit is concerned, it is apparent from the record that it was an afterthought. Full stop.